also have a legal defense fund, and we have been doing a number of legal challenges over the years. This is expanding quite a bit since the passage of the SAFE Act. But a couple of the cases we had, Scope versus Pataki. If you remember back in 2000 when George Pataki passed his 5-point plan, one of those 5 points was that if you go to a gun show, you have to have a background check. Well, the definition in that law of a gun show was so broad, they could have come in and said, this is a gun show, and if anybody had even talked about purchasing a gun, they could have potentially charged you for it. Or a pancake breakfast at your club. So we sued over that definition. At that point, we won that suit, and it was still the law that you had to have a background check at a gun show, but since this, it actually had to be a legitimate gun show where they're actually setting up tables and selling guns. Chwick versus Mulvey was a case in Westchester County. Westchester passed a law that outlawed what they called deceptively colored guns. They actually had a list of what color your gun could be, and if it wasn't, blued or there was a short list, and if it wasn't that color on that list, then you could be arrested, be charged a $1,000 fine, and spend a year in jail. You could go buy one of those Kel-Tec pink pistols or like lavender guns, pass your government background check, have it registered, do everything else, and then you drive through Westchester or Nassau County with it, and they could pull you over and arrest you and put you in jail for a year. We had that overturned, and in that language, we got some very favorable language in that suit that said that the state licensing system is meant to be all-inclusive and that the localities cannot add restrictions not provided for in state law. We were very excited to get that ruling, and our plan was to go forward at that point county by county and challenge all these local restrictions that many of the counties are putting on the licenses. That's still kind of in our long-range plan, but shortly after that we got hit with the SAFE Act, and that kind of blew a lot of things out of the water. Chukowski is a very prominent case. In Westchester County, Westchester was saying that you could not have a pistol license unless you could demonstrate that you had a greater need than the average person to defend yourself. So we took them to court on that. That went up to the Second Circuit Court of Appeals, and unfortunately we lost on that case. Second Circuit ruled against us. We filed an amicus brief on it, asked the Supreme Court to take that case up. The Supreme Court did not. So at this point, that became precedent in the Second Circuit Court of Appeals. Since that time, there's been another case out in the Ninth Circuit, which typically is one of the most liberal circuits in the country. But a case, Peruta versus San Diego, where they challenged a similar ruling, that they were doing the pistol licenses on instead of a shall issue, a may issue basis. They were making you prove your need for it. And the Ninth Circuit actually ruled against the city of San Diego on that, and ruled that they couldn't do that it's a right, that you don't have to prove a need for a right. At this point, that makes a split in the circuit courts, and that makes it ripe for another case to come forward to go up to the Supreme Court. Since then, that Peruta case has been challenged, and it is going for an en banc review, as they call it. It was ruled on by a 3-judge panel. The entire Ninth Circuit panel is 9 judges, so it's going to go before all 9 judges at this point for review. And that's one of the ones we're watching. Karen versus Andrew Cuomo is one that we came out with right after the SAFE Act passed. You're all very familiar with the New York State Rifle and Pistol Association case. And for as much as people that I've heard over the last couple of years complaining about the NRA and they're not doing anything in New York, they have spent almost $750,000 on that case to date. But this was concurrent with that case, But rather than having a very broad-based case, the way the Rifle and Pistol Association, this was very narrow, tailored, on a single issue. We felt it was the low-hanging fruit we could pick off on the 7 and 10 round magazine restriction. After this case was not decided until after the ruling from Judge Scretany in the Western District Federal Court, and one of the things that he ruled was that that 7 and the 10 round magazine was unconstitutional. At that point, there were some DAs around the state saying, well, that only counts in the Western District, doesn't count in the whole state. That's bull. I'll tell you that straight out. The only way that it doesn't count for the whole state is if you have a competing ruling in a different district. And immediately when they started saying that, we put out a press release and put out specific case histories or cases that showed that that was not the case. But since there was some confusion on that, we continued forward with that case, and on March 31st of last year, we came to an agreement, a stipulation from the Attorney General's office that we would stay the case with the stipulation that New York State will issue instructions to all state agencies, not just the state police, but every state agency that that ruling in the Western District Federal Court applies to the entire state. So no state agency will attempt to arrest anybody for having more than 7 rounds in their magazine. If they were to go back on that case it's not, hasn't been withdrawn, it's just stayed, so that could potentially be reactivated. The Rosano case was not one we were directly involved with, although we were in pretty close communication with the attorneys on that case. That was another case down in Nassau County. A man named Gabriel Rosano had quite a few guns, and he was upset by our Congressman Carolyn McCarthy. Does anybody know Carolyn McCarthy? She's probably one of the most anti-gun congressmen in the entire House of Representatives. So he wanted to talk to her about her anti-gun stance. He went to her office, and right away they said that he was a threat, that they were afraid of him. They called the police and had him escorted out. He never was charged with anything, never broke any laws, never made any threats, even though they felt that they were afraid of him. So immediately it was reported to the local pistol licensing officers. They revoked his pistol permit with no hearing, no evidence, no charges, no nothing. And at the same time, not only did they take away all of his handguns, they took away all of his long guns as well. He spent, this was in 2004 I believe, he spent a number of years going through court, was able to finally recover his long guns, although he never did get back his handguns, and he never got so much as a hearing on his pistol license. Then along comes the SAFE Act, and the SAFE Act says if you become ineligible to have a pistol license for any reason, they come and take all your long guns. So he's like, here we go again. Now, according to the law, they're going to come take all my guns again. So he filed this suit, Rosano versus Cuomo. And, you know, when we talk about these court cases, we have to often talk about a lot of convoluted rulings, and this was one of them. The judge in that case said, well, you don't have standing in this case, because even though the law says that all your guns should be taken away, they haven't all been taken away. So this is all hypothetical, and they dismissed it and sent it back to the lower state court. So that remains to be seen what's going to happen from that case going forward. There's another case out of Nassau County we're watching right now. In fact, Paloma is one of the consulting attorneys on another gentleman who, very similar case, was not charged with any crime. It was an argument in his house where voices were raised. Somebody called the police. The police came to his house and took away all his guns. $100,000 firearms collection. Confiscated the whole thing. And that case is I forget the gentleman's name, but that case is ongoing now as well.
Montgomery?
No, that's not Montgomery. Although, what happened here? Sorry about this. There we go. The Montgomery case was a gentleman named Don Montgomery, who was a 30-year law enforcement professional, detective near the end of his career, Navy veteran, and he retired and was moving from Suffolk County to Monroe County. And during the whole process of selling his house, buying a new house, moving, the whole thing, he was having a little anxiety about the change of life and everything, so he was having some problems sleeping, insomnia. No big deal, but you know, if you don't sleep for a long time, it gets to be an issue. So he ended up going to his local hospital in Suffolk County and checked himself in. Basically, spent a couple nights sleeping there. Was checked out 2 days later, and everything was fine. Until a few days later, gets a knock at the door. It's the Suffolk County Sheriff's Office. We're here to confiscate your guns. They had said at the hospital, they coded him as an involuntary psych admission, which, number one, it wasn't involuntary. He checked himself in. It wasn't a psych admission. It was an issue with insomnia. So they tried all the remedial things first. They tried to go to the hospital to get them to change the coding. Apparently the hospital was glad to do it, because if they change it, that they have to admit they're wrong, and they were afraid of being sued. They tried to go through the Suffolk County Sheriff's Department. Look, this is baloney. Had to go to the state, DCJS, where all the records were sent through. They told him the records were confidential. He couldn't have them. The records about him, but he couldn't have them. So he ended up having his secondary rights taken away, all his property taken away. He can't have a gun. He's now one of 4 plaintiffs on that suit, the Montgomery suit, where they're challenging that. They are calling for a injunction to stop this mental health 946 reporting system, which is part of the NY SAFE Act. And they're calling for everyone who has been reported under this system to have a notification from the state of a HIPAA violation, because it clearly violates the federal HIPAA laws. I just talked to another gentleman the other day who called my office, and a very similar situation. He had an argument with an ex-girlfriend who he had to pay child support to. She wanted more child support. Couldn't afford it. She began berating him, and he told me, he says, you know, he says, I know it was stupid, but he said something like, oh, geez, you know, this makes me want to blow my head off, or something like that. Next thing you know, she's on the phone to 911, calling the police. They're calling him. They pulled him over. They got him on his phone. They pulled him over, had the state police pick him up on the side of the road, went immediately to his house, confiscated all his guns, took them all away. So it looks like he's going to be plaintiff number 5 in this suit. And we're seeing it more and more all over New York State through result of the SAFE Act. A couple other suits we're working on now, this Scope versus Cuomo. What that is it's a Article 78 case in the state Supreme Court in Albany, because we have filed a series of Freedom of Information Act requests, 33 Freedom of Information Act requests, asking things like, how many people registered their assault weapons? We're not asking for any personal information or any identifying information, just how many records do you have? They won't give us any of that. We ask them for what is the training protocol for the state police who answer the hotline about the SAFE Act. We don't have any records on that. So apparently there's no training protocol, which might explain why if you call one day and you call the next day, you might get two different answers, because apparently there is no training protocol. 33 different things, including previous drafts before the final draft of the SAFE Act. We had no records of that, they're saying. Apparently it just came complete, fell out of the sky on January 13th, and there it was, no previous records. Of course, we actually have testimony from Andrew Cuomo himself in his autobiography about how they were working on it for months and all the different people who were working on it, and yet they are claiming in court that there are no previous records. So that is pending at this point. And there's numerous ones on that. The last one, Scope and myself versus Cuomo, is about last year at the rally on April 1st. They were going around confiscating people's pictures of guns or a cardboard cutout, telling people you can't even have an image of a gun, a rule they just made up just for this this case. And we asked for records for that, Freedom of Information Act request, how that was all done. We were told by the Cuomo administration lawyers that all of that information was protected by attorney-client privilege. We asked for in-camera review from many lawyers in the room, which essentially means that we asked the judge to look at those records, and if anything is not covered by attorney-client privilege, the judge to let us know and give us those records. So that case is ongoing now as well. Also the New York State Rifle and Pistol Association case, again, I want to stress, so many people are saying the NRA is doing nothing for us. I'm a life member of the NRA. The NRA has spent nearly $1 million, or over $750,000 on that case right now. What we're doing, we're not a party directly to that suit. We're putting together an amicus brief asking the Supreme Court to take that case up and review it. We're building a coalition of organizations. Right now we have over 125 organizations across the state. Sportsmen's clubs, Conservation Council, various federations from all across the state, and most recently we've added on the New York State Association of Former Troopers, the New York State Sheriff's Association, the Erie County Sheriff's Deputies Union, and we'll probably be adding a few more law enforcement organizations to that as well, to sign on to a brief to ask the Supreme Court to take up and review that case.